Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open. 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air. Well, a lot has happened over the last week or two, and I've been saving up for this particular podcast only because of the fact that I keep getting these questions about this December the 1st cutoff in terms of the new Fair Labor Standards Act salary test. And the question I keep getting asked is, well, besides how did this happen in terms of who got elected, is what's going to happen now since Trump is president, or at least he's going to be president, so let's call him President-elect Trump. What are we going to do with the Fair Labor Standards Test that's going into effect December 1st? Now, I did a little research because I really wanted to look something up. If you take a look at Trump's campaign website, he has an entire page dedicated to regulations. He's a guy that does not like regulation, so you have to start with that and understand what his campaign had promised to do, not do, etc. But if you look on there, you're going to see a couple of things. He's going to ask all department heads to submit a list of every wasteful and unnecessary regulation that kills jobs. And quite frankly, he wants to eliminate them. So what is he going to do? He's going to scale it down a little bit. Then he wants to reform the entire regulatory code to ensure that we keep jobs and wealth in America. So what does all of that mean? Well, he's talking about decreasing the size of our already bloated government, and he's going to do a thorough agency review. Now, when he does a thorough agency review, understand that's going to mean the National Labor Relations Board as well. The NLRB will be in that. And the way I look at this is that there's going to be some changes coming. However, stop and think about it in answer to these questions when they said, what is this going to mean regarding the new FLSA salary test? Well, here's the short answer. Doesn't mean anything. December 1st, is just right around the corner, as we already know. And based upon that, he's not going to have time to react to that. Beginning November 1st, for those of you who do not know, the salary level for white-collar Fair Labor Standards Act exemption, called the FLSA, is going to increase to $913 per week in order for somebody to be found to be exempt from overtime. Annually, that works out to approximately $47,400. So for all those managers out there that are making less than that, and they're going to get a huge pay increase for some of them. So obviously employers are concerned about it. Now, just stop and think. The new regulation rolls in on December 1st. Trump is not going to become the president until about 51 days later. There's no time to do anything. So even if he wants to stop them from this taking effect, he's powerless to do so. And any legislative effort would die at the hands of the current presidents by veto. Barack Obama is not going to endorse it. So there's no point in anybody even dealing with it right at this moment. So now, there is some federal court judges that are looking at this and trying to put a stay on it. Check my blog very carefully because we may have a delay, but a court-ordered delay as opposed to a Trump delay. Now, what about the long answer? Because I'm only talking about as of December 1st. Now, there is a possibility that once he gets into office, he and the legislators can now take a look at this a little bit more carefully. Something might happen. If you ask any small business owner, the new salary test checks. Each of these are Trumpanian boxes, if you will, that breaks down all of these little checkoffs that he wants to do when he gets into office on the first 100 days. There's just too much. So what do I tell employers? You better knuckle down, bear down, and get ready to do what you have to do. You can't hope for a reprieve on these rules. So just be prepared for it. Now look, I'll tell you what some employers are doing. Some employers are changing managers from a salary to an hourly amount. Now, if you really think about it, you've got a manager, they're making less than $47,400. Some of them do not even spend a 40-hour work week. I get that complaint all the time. Some of them leave early anyway because of the fact that they're salaried. If you turn around and put them on an hourly basis, that could be a big difference. Now they'll probably be there that 40 hours, and now they'll probably try to work the overtime now that they know they're going to get paid for the overtime. So what would I suggest? Monitor the overtime. What they couldn't do before, in terms of, the leaving early, etc. Now hold their feet to the fire. But because they're hourly, you won't have to do much holding. Trust me, they will be there the 40 hours because now their compensation plan is depending upon that. And now you'll find where managers are going to claim, hey, I've got to stay longer. I got to get the job done. So I would go back and look at, you probably don't have time records on them, but just think back in terms of their hours that they worked before. If you felt that already they were suffering from leaving before 40 hours was fully worked, then here's the deal. Hold their feet to the fire. Tell them there's no overtime. Get your job done in 40 hours. Now, if you need the overtime, then you need the overtime. So that's one solution that some employers are doing. Other employers, they're just moving it up to the 47.4. Some businesses, the managers are already making more than 47.4. So it's not a big deal for them. I know some industries that are highly compensated industries that doesn't make any difference. So, bottom line, there's not going to be any change just because Trump got elected, at least not in the immediate future. So don't worry about it. Do what you have to do financially to make whatever adjustments that you have to make and move it on forward. Now, I've talked in the past also about discrimination. I've done that on a number of occasions. And I've also talked about social media, which includes Facebook. And, Facebook can actually be a help or a hindrance to employers. And I came across something that I thought was kind of comical in a way, and I thought that I would share that with you. And is what this is about is a woman has claimed discrimination, and she claimed racial discrimination against her employer. Now, she files a lawsuit, and as they're going through the process and they're doing their investigation from the defense side, they actually turn around and take a look at her Facebook. Now listen to this. The plaintiff's Facebook page ended up being prejudicial to her case. You see, these employees do not realize that when they're on Facebook or some of these other social media sites, how some of that can come back and haunt them. I'll tell you a story about another one in a moment. But here's a particular one where this lady was yelling racial discrimination, and she had a Facebook page. Now, interesting, some of the plaintiff's comments on her Facebook actually support the claim she asserts in the case, and the plaintiff has used these posts to substantiate her claims because she had things that she used for her evidence that she pulled from another Facebook page. Now, it also relates to whether the plaintiff was offended by such conduct at work and whether this conduct forced her to resign since she herself participated in the comments containing racial stereotypes and jokes on her own Facebook page, which were in part insensitive and demeaning. So is what ended up happening was the employer's defense team ended up getting copies of the Facebook page that showed that basically she was being a hypocrite. Whereas in one respect, she was stating that she was being discriminated against and she found, racial comments, personally offensive, but yet she was participating in it herself with the same kind of behavior and making jokes about racial comments, etc., on a social media site. So, the message is clear that everybody needs to be careful about the social media sites, Facebook. I had a client that was sued by a Middle Eastern gentleman, and this individual would walk into a meeting, open up his coat and say, "See, no bombs." And then, of course, is what would happen was, other guys in the room would make comments. Well, this individual ends up losing his job. And then after he loses his job, he wants to say the reason why he got terminated was because he was of Middle Eastern descent. Okay. So what does he do? He goes and gets an attorney. They're a dime a dozen, especially in plaintiff attorneys. He finds an attorney. He tells this attorney, "Let me tell you what happened to me." And he goes through and he explains about how they've made comments to him. He's been teased. He's been humiliated about his Middle Eastern descent. Well, he sends a letter. His attorney sends a letter to the employer. The employer forwards it to me for review. And I take a look at the letter and I talk to the client. And the client says, "You know what? This individual had a tendency to joke about his Middle Eastern descent." And I told this attorney what I just mentioned about seeing no bombs. Now, his attorney tells me, "You know what? This guy is very serious. My client is very serious about his Middle Eastern heritage, and he would not make any comments and joke about his Middle Eastern heritage." And I'm like, "Really?" He's like, "Yes, he's a very serious person." Well, we ended up saying, or at least agreeing to go to mediation. And this is all before a lawsuit's filed. So we ended up going to mediation. 3 days before the mediation, what do we discover? We discover a Facebook picture of the plaintiff sitting on the hood of a car with 2 AK-47s and him saying in there, "It's a Middle Eastern thing." Him just clowning around like that. So this is the same person that says that he, in fact, or his attorney says that he takes his Middle Eastern heritage serious. So here we are at the mediation. What does his attorney ask? His attorney wants some ridiculous amount of money of $300,000. So, mediations can be, very lengthy. We go back and forth, grinding each side, trying to grind the other down. And then finally, after hours of being there, I then pull out this picture. I send the picture into the other room with the plaintiff and his attorney through the mediator. What did the case end up settling for? Only $30,000. And quite frankly, it probably shouldn't have settled for that because the employer really didn't do anything wrong. But $300,000 down to $30,000, all because of a Facebook picture. Now, I'll close in just saying that, look, employers need to understand about this business about documentation. Documentation can come from anywhere, from any direction. Social media, non-social media. Social media can help you, it can hurt you. I'll say the same thing about emails. I'll say the same thing about text messages. I'll say the same thing about voicemails. These days, the message out there is to be careful with these things. Technology is changing the way that we live. So you need to be extremely careful. In this particular case, with this lady, with the racial discrimination and the Facebook page, I tell you, the reality is the court felt that there was evidence in the case that at times the plaintiff initiated and engaged in racial jokes and comments while at work with co-workers. The comments made by the plaintiff and the comments liked by her on her Facebook page was used properly to challenge her credibility. The credibility of the witness is for the jury to weigh. This evidence is also relevant whether the plaintiff truly found the comments made by coworkers as offensive and unwelcome. Point is, didn't matter. If in her past she endorsed that kind of behavior and laughed and joked about it herself, clearly she would not have been offended by any comments. So managers and supervisors out there, take heed. When these individuals start engaging in this behavior, look back in the past and see whether or not the individual had engaged in any kind of business like this in the past. And by the way, that applies to sexual harassment as well. All right, with that last comment, it's time to close out this segment. But let me remind you that you can also hear us on Facebook at Listen Up and subscribe to us on iTunes. Just look for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday. We can be reached at 855-4J-POTS or 855-457-6887. Or you can email us at listenup@jameswilliampottsllc.com. Okay, I'm Jim Potts. I will continue to fight the fight. Thank you for listening.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.